Welcome, everyone. Delighted to see you back for one of our ALN Academy talks. Today, we will be discussing some very interesting cases that are currently proceeding under the Convention for the Prevention of Genocide. What we will be discussing will touch on some distressing topics, but it's very important for us as legal practitioners and lawyers to understand what the international frameworks are for prevention of genocide, and also to understand different perspectives around the frameworks. One of the main reasons we're doing this is to explain to our audience in Africa and outside Africa why we are finding African countries bringing these cases in relation to events that in many cases are very far away from their borders. So with that brief introduction, I would just like to invite my guest speakers today to introduce themselves. My name is Aisha Abdallah. I'm one of the directors of the ALN Academy, and I do a lot of work around disputes, but I'm joined by a very distinguished panel. I have my fellow co-director. Perhaps, Angeline, you could introduce yourself now.
Thanks, Aisha. My name is Angeline Welsh. I'm a barrister at Essex Court Chambers and specialise in international arbitration, working on investment treaty and commercial cases, and also sitting as arbitrator.
Thank you. And we have an expert with us here today, Professor Marco Milanovic, who's head of Professor of Public International Law at the University of Reading in the UK. Professor Marco, perhaps you could just give us a little bit of insight about your involvement in international criminal law cases, international human rights law, and any background you are bringing to share with us today.
Sure. So some of the areas I specialize in are the law of state responsibility, international criminal law, and I've written many years ago in the European Journal of International Law on State Responsibility for Genocide. I also worked as a law clerk in the International Court of Justice, the court which is now hearing these genocide cases.
Thank you, Professor. So perhaps we could just start with the fact that we've recently been reading about the case brought by South Africa against Israel in relation to the conflict taking place in Palestine and Gaza. But Professor Marco, isn't it true that this is not the first African nation to bring such a case before the ICJ? And perhaps you could explain the previous case we know about.
Sure. So before South Africa brought this case against Israel, there was another African state, Gambia, that brought a case against Myanmar with regard to Myanmar's mistreatment, including killings of the Rohingya Muslim population in Myanmar. But that was not also the first genocide case before the International Court of Justice. You know, the first big genocide cases before the International Court of Justice actually dealt with my country, with the former Yugoslavia, where we had two cases brought by Bosnia and Croatia against Serbia, dealing with the wars in the 1990s. And it's really these two judgments in these two cases that set the stage for a lot of what happens. Two really basic points come to mind. One is that the Genocide Convention provides for a jurisdictional basis of bringing a case to the International Court. The other is that the crime of genocide in the convention is actually very narrowly defined, much more narrowly than most ordinary people, even most lawyers, would think it is defined.
Thank you, Professor Marco. First, let's just come back to this issue of geographical distance and the link to jurisdiction. So I think, as you've explained, the cases against Yugoslavia, they were brought by neighboring countries. But if you look at Gambia, very far away from Myanmar, South Africa, not a close neighbor to Israel. In fact, there are many nations around Israel that might have been better suited to bring this type of claim. Is there a link? Do you have to be close geographically, or could you explain to us why it is possible for these countries to be bringing these types of cases?
Sure. So that's an excellent question. I mean, typically what you really have is a country which claims to be the victim of genocide at the hands of some other state, sue that state. So that's what happened with Bosnia and Croatia and Serbia. It is sort of, but it's a bit more complicated also what happened with Ukraine suing Russia. Here, you have completely uninvolved countries suing another state, claiming that it is committing genocide either against its own people, which is Gambia versus Myanmar, or against the population of Palestine, which is South Africa versus Israel. And so in these cases, and in some others like Belgium versus Senegal that dealt with potential extradition of Hissène Habré, the former dictator of Chad, the International Court of Justice basically affirmed that some obligations are owed to the international community as a whole. So these are what we call erga omnes obligations, and that all states, even if they have no direct involvement, have a legal interest to file a suit before the International Court. So that means that Gambia, even though it has nothing to do with the Rohingya people in Myanmar, had standing basically to sue Myanmar. And the same thing applies to South Africa suing Israel.
Right. But obviously, from what you're saying, it is not possible for an individual to bring these types of claims against the state.
Correct. So the International Court of Justice is open only to states, not even to international organizations. So only states can bring cases before the International Court of Justice. There are other courts that are open to individuals. These are international human rights courts. However, in the particular case of Israel, Israel is not a party to any such mechanism. With regard to, for example, Russia was a party to the European Convention on Human Rights, and so that's why the war in Ukraine is partly being litigated in the European Court of Human Rights.
Right, very interesting. The second point you made was the one about the very narrow definition of genocide. I think it's important in this introduction to explain to us why the concept is different to what probably we have in mind as a general public.
Right. So that's a really crucial point. And the answer is really political. There is no inherent meaning to this word genocide. The word genocide was coined during World War II by Raphael Lemkin, this famous Polish Jewish lawyer who was lobbying the UN after the war to adopt first a declaration, a resolution, and then a convention. But the states parties at the time, in 1948, had to agree to a definition. And they had to agree to the very first crime, international crime, that could be committed in peacetime. It was a huge step. So before that, there was no crime that a state could commit against its own people in peacetime. And genocide was the first such international crime. And that's why the UK, the US, the United Kingdom, France, Russia, the Soviet Union at the time, they all had to agree to this definition. Remember, Stalin was very busily killing his own people, and he had to agree to this definition. And so that's why they agreed to something fairly narrow, something that could basically capture the Holocaust and not much else beyond that. So the definition is found in Article 2 of the Convention, and it involves the commission of certain acts. Killing is, of course, the prototypical, but so is, for example, preventing births within a group. But what distinguishes genocide from other crimes is the specific intent with which it is conducted. So the crime has to be done with the intent to destroy, in whole or in part, a racial, national, ethnic, or religious group as such. So that's the key distinguishing characteristic of this crime. It's not the number of people you kill. It's not even the way you kill them. It is the intent of the perpetrator. And it is really proving that intent that is the most difficult issue in all legal cases.
So on this very difficult point, I'd like to hand over to Angeline to take up the questioning.
Well, before we get into that, Marco, just going back onto this question of why these claims are being brought by African states, or maybe we can say states which are not geographically close. And I think you explained very well that there are international obligations which arise presumably specifically under the convention. But what do states have to do beyond that in order to show that they have standing to bring a claim? One of the things that I thought was really interesting going through the Gambia and Myanmar decision in particular as a starting point was this question of the objection which was made by Myanmar is that the real applicant was the Organisation of Islamic Cooperation, which was something rejected by the court. But if when we're thinking about the motivation of some of these states to bring this type of claim, to what extent is the ICJ going to interrogate the political basis upon which these sorts of claims are brought or not?
So basically, the court is never going to interrogate political motives because there's always going to be political motives. So there is, never a single piece of international litigation brought by states that is not inherently political. Somebody in that state had to make a political decision that filing that case is in the state's best interest, and different states make that assessment on the basis of different considerations. And so I don't want to speculate, you know what I mean? But in terms of Gambia filing the lawsuit against Myanmar, I think probably Gambia, as part of the Organization of Islamic Cooperation, wanted to show something together with all these other states, that they're doing something for the Rohingya Muslims, that they're not forgotten. Yeah, in a sense, Gambia enhanced its standing in the international community. South Africa, of course, you can say it's fighting for justice and so on, for all sorts of things. But South Africa probably made a political calculation that it is in its best interest in terms of reputation in the eyes of the international community to do something like this. And it's always going to be political. So the court basically says, the fact that a particular dispute before the court has political dimensions does not mean we are not here to answer legal questions. We're answering legal questions, and that's our job. The fact that states have political motives, well, fine. That's life.
So, following on from what Professor Marco just said about all these cases would naturally have a political element. I think that is automatic because of his explanation at the beginning, that they can only be brought by states. And states, by their nature, are political entities, an affiliation, a collection of individuals who've identified themselves politically in a particular way. But what I think is interesting about, if you compare, and this is not within, this is completely outside speculation, but if you look at Gambia, Gambia is a majority Muslim nation and is a member of the Organization of Islamic Countries. But if you look at South Africa, South Africa has actually the largest population of Jewish people in Africa. And I thought that was an interesting fact. And yes, it also has a large minority Muslim population, but you could see that there's no way South Africa would have the same types of motivation as a country like South Africa. And so there must be something else going on politically that made it prudent at that time for them to take a step. But I just thought that was an interesting contrast.
That's true. So in the case of South Africa, I think the biggest issue really is the long-standing affiliation between anti-apartheid ANC leadership in South Africa and all anti-colonial movements or all national liberation movements, including the Palestinian ones. So that's really the main connection. That's what they see as the kindred spirit, and that's also what plays well domestically.
Yeah, I think that's true. But even if you look at South Africa historically has always had the South African government after apartheid has always been very closely linked with Yasser Arafat's PLO party, but hasn't actually ever been linked with Hamas. So I'm just saying there's so much nuance in this.
Sure.
And yeah, that's probably the subject of another person's PhD thesis. Angeline, back to you.
My question seems quite boring now.
We'll give you another one. We'll give you a...
So Mark, I think you've explained what the court will look at, or whether they will look into this question of political motivation. The short answer is no. What about establishing an existence of dispute between contracting states? What does the applicant state have to show in order to identify that there has been a dispute or a dispute has arisen?
Right. So there's really two basic points when it comes to the court's jurisdiction. First of all, the court's jurisdiction is only based on state consent. So this is not like in a domestic court where, in principle, you don't ask somebody for their consent before you sue them. States are sovereign entities, and there's no way to get a state before the international court unless it has accepted that it can be put on trial. The core problem here, though, in this case and many other cases, is that the jurisdiction is based on a clause in a specific treaty, and it only pertains to that treaty. So the jurisdiction in South Africa versus Israel case is based on Article 9 of the Genocide Convention, and that means that South Africa can only argue genocide. South Africa cannot argue, for example, war crimes, crimes against humanity, any violations of international humanitarian law, because all of these are outside the scope of the court's jurisdiction. Israel never consented to it. So that means South Africa has to make its whole case about genocide. So that's one problem. The other issue is this procedural admissibility question of existence of a dispute, which is what you primarily raised, Angeline. And here the court basically created a jurisprudence that says, we're not going to allow you to surprise a state simply by filing a lawsuit. Yeah? You first have to engage with it at the international level so that we have evidence that there's a dispute, some kind of diplomatic engagement normally, a clash of two opposing legal or factual views, and only then is it appropriate to go to court. Yeah. In most cases, that hurdle is going to be overcome, and I'm sure it will be overcome in this particular case too.
And does that have to be the two states who are party to the proceedings or primary party to the specific?
Correct.
Right.
Correct.
But
correct. And South Africa has tried to show that it has communicated with Israel in various ways, alleging that Israel violated the Genocide Convention. Israel denies this. And, you know, they're going to have this exchange of arguments when we reach the jurisdictional stage of the case. South Africa is almost certainly going to win on that point.
Sorry, so just to jump in there, so is it a prerequisite to filing this case that South Africa would have essentially sent what we think of as a demand letter to Israel? Is
something like that? So it doesn't necessarily have to be a demand. It's not formalized in that way, but basically the court will rule a case inadmissible if no dispute existed before the filing of the case.
So statements in the public could amount to demand.
Could amount.
What you're saying.
So, you know, you stand up in the UN General Assembly and say, I accuse you of committing genocide. The other state says, no, we didn't. That's a dispute.
It's very interesting.
And so we should probably say, I was thinking that the cases are still not finally determined. I think that's right, isn't it? So,
correct. I mean, they're the earliest possible stage, all of these cases.
But so I think that's quite important, isn't it? Because what the ICJ has taken is just a preliminary view as to its jurisdiction. So jurisdiction is not finally determined.
Correct.
Because it's been asked to issue interim measures, it has to take a preliminary view of.
Good. So let me explain a bit sort of the
substantive claim. Yeah. Do you want to go ahead and explain it? Yeah.
Yeah. Let me explain sort of the procedural stages of a case before the ICJ. So, you know, one state files an application against another state. At that moment, if there's an urgency of irreparable harm to its rights and interests, it can ask the court to issue a provisional measures order. So then the first order of business, normally within weeks or a month or something like that, is for the court to hold a hearing on provisional measures and issue an order, normally again weeks after that hearing. So that's the first stage. Then a year or even two after that, the court will have a hearing on jurisdiction in that case. So normally the respondent will file so-called preliminary objections, objecting to the jurisdiction and admissibility of the case. So then there will be a jurisdictional judgment where the court will decide, yes, we do or we do not have jurisdiction. Then they will have hearings on the merits, exchange of written pleadings, and then hearings on the merits. And that can take years. And only after that, there will be a final judgment on the merits. So in the Gambia-Myanmar case, we are now at the merits stage. Yeah, so we're waiting for essentially the merits judgment. In this case, in South Africa versus Israel, the court only issued two provisional measures orders. One of the conditions there was to say it had prima facie jurisdiction. It'll have a jurisdictional judgment a year or two from now, then there will be a merits judgment many years later, probably.
And in situations like this, that the importance of provisional measures is high, isn't it? Because
yes.
by the time the court actually comes to issue substantive determinations, matters may have moved on. And they become historical, hopefully, historical events. So there is a huge amount of pressure on the interim measure stage. And one of the questions I had for you was about how effective they are. And that might be in terms of the type of relief that they can give and how responsive states have been to that relief. But there may also be a broader international political dynamic in play here as a result of any court decisions issued. Is that something you could perhaps explain, Marco?
Yeah, that's an excellent question. So sometimes a state's main motive in bringing a case is to get a provisional measures order. That's the basic reason why the case is being brought. It's not really being brought because 3-5 years down the line, there might be a merits judgment in its favor.
Yeah.
It's really often that immediate moment where the state needs something done. Very often states get disappointed at this stage. I mean, I can tell you, so when Bosnia sued Serbia, this was at the height of the civil war in Bosnia, or not just the civil war, but of course a war in which Serbia and Croatia were also intervening. And what Bosnia really wanted was the court to overrule the UN Security Council and overturn an arms embargo that the Security Council had imposed. And the court just said, go away, we're not doing this. Yeah. So very often, states will get disappointed at the provisional measure stage. Sometimes they will get things they want. So Ukraine sued Russia at the start of the wholesale invasion at the beginning of 2022. And within weeks, the court told Russia, you have to stop the war, full stop. That's what the court ordered. Just stop your military operation. Russia refused, obviously. But Ukraine did get some form of vindication in the eyes of the international community. There was the highest court of the UN telling Russia to stop, and Russia refused to comply.
Yeah.
Which brings me to your question of compliance. It's incredibly difficult to measure this. So you really, it's an empirical question. When you have cases with high stakes like these, as you can imagine, the compliance record is going to be very spotty.
Well, one of the things I noticed on the South Africa and Israel case is that Israel has to produce a report to the court as to its compliance. And obviously, one of the things that Israel raises in its defense is it talks about the humanitarian steps that it's taken in conjunction with its military action. And so, I mean, I don't know. One question, I suppose, is how useful are those reports, and to what extent having relief from the ICJ does influence policy in terms of how this conflict situation is approached as a matter of practice. I mean, I don't know whether it does or not, but I was quite interested to see that almost the court takes a monitoring role in effect.
That's right. So when it comes to that reporting mechanism, it was, I think, first deployed, especially in, particularly in the Gambia Myanmar case. However, the reports that are filed by the respondent state are confidential to the court and the applicant state, so they're not made public.
And are they not?
There's no naming and shaming.
Only to the applicant state, so it's not, because many states intervene in these cases, don't they? So who are these reports shared with?
So only the parties, and the intervening states. I mean, intervention is a whole different ballgame and really becomes relevant only in the later stages of the case.
Right.
So the reporting obligation is really a form of that state being forced to communicate to the court and tell it what it did, and later it might be relevant to assess, for the court to assess whether the state complied with the order. Because in the judgment on the merits, the court will also determine whether the order was complied with, the provisional or measures order was complied with. So it's not something publicly, opening the state to public scrutiny. This particular case is really interesting as a case study, and I think it'll require more distance from the events to properly assess what the impact of these orders were. But to cut a long story short, so the first order was issued in January 2024, at the end of January. The second one was issued at the end of March. And essentially, at the first stage, so the first order, the big question mark was this: will the court order Israel to stop the military operation, and just end it there? Or will the court adopt something much more ambiguous? And the guess of most observers, including me, was that the court will not tell Israel that it has to stop the war in Gaza. And that's what happened.
And is there a practical assessment to that? Because the ICE, much like the Russia-Ukraine situation, if the court were to say to a state, please, stop this action, that's arguably unrealistic, isn't it?
So that does have some role, right? So if you're a court, you want to induce compliance. You don't want to issue decisions that nobody wants to comply with. Yeah. On the other hand, you don't want to appear weak either and cowardly. So it's a finally, law aside, there's a political calculation, obviously, there as well, institutionally, in terms of what that court is equipped to do.
Can I just interject there? So I just had a couple of questions around this issue of provisional measures, because obviously ICJ has ordered Russia to stop the invasion of Ukraine. So it has issued an order that, most of us would have thought would never have been complied with by Russia, because if it was that easy, I don't think we'd have had the invasion of Ukraine. So what that made me think of is, for example, if Russia's invasion is successful and it wholly takes over the territory of Ukraine, such that by the time there's a merits hearing, there is no independent Ukraine government to continue prosecuting the suit, could that be a tactic where you basically just withdraw? You could just then, another guise, withdraw the case against Russia. Once you file a case, is there a way to have it withdrawn?
Yes, so cases can be withdrawn. Normally, after a certain stage, both parties need to agree to the withdrawal. There have been attempts through government changes to withdraw some cases. So this actually happened with the Bosnia-Serbia case. Bosnia, after the war had ended, this whole new power sharing arrangement was created, whereby all decisions had to be made by this tripartite presidency, a Bosnian Serb, Croat, and Bosniak Muslim. And when the Bosnian Serb person became the president of the presidency, he sent a communication to the court saying, we withdraw the lawsuit, even though the two other guys said, no, we're not withdrawing the lawsuit. So sometimes you will have like that. If Russia takes over Ukraine completely, I think Ukraine's least concern will be this ICJ case, if you see what I mean. So in that sense, that's not the biggest problem there. In Myanmar, the interesting issue was that as the respondent state, there was a military coup while the case was ongoing. So Aung San Suu Kyi was overthrown, you'll remember. And then all of the legal team of Myanmar resigned. Myanmar had to hire new lawyers. So these are interesting issues. Ultimately, the reason, however, why the court gave that order in Ukraine versus Russia is because the case was different. In Ukraine versus Russia, the claim was not really that Russia committed genocide in Ukraine. The claim that Ukraine had brought was quite innovative. Basically, they said, Russia says that we, Ukraine, committed genocide against Russians in Ukraine, and on that basis, use that as a pretext to invade us. So basically, a claim of genocide was the pretext for the invasion. And that's what the court said. It's a plausible right, not to be invaded on the basis of this false claim. We order you to stop the war. Now, however, there was a jurisdictional judgment in that case, and Ukraine lost, essentially. So lost on all of that big stuff. And the only thing left over in that case is that the court will decide whether Ukraine committed genocide
against Russia.
Not against Russia, but against its own people. So Ukraine is almost suing itself, now in the court, because the court said all of that use of force stuff is no longer within our jurisdiction.
Right. Very interesting.
Basically got what it wanted. Ukraine got the provisional measures order, but on the merits, that case is dead as far as Ukraine is concerned. Ukraine gets nothing out of the continuance of that case.
But in the Gambia case, was there a provisional order
Yes.
made?
Correct.
And what
Yes,
was
there
it?
was, and that's where the court first used this reporting function. Now, obviously, all the the civil war in Myanmar has continued, atrocities have continued, so it's difficult to say that that order had a major impact. The South Africa versus Israel order, however, the second one in particular, you can see the court is responding to the unfolding famine in Gaza, and the court has ordered a more specific set of things of Israel in the second provisional measures order, so at the end of March, essentially ordering Israel to ensure access to humanitarian relief to Gaza. Now, to what extent that will actually influence Israel is impossible to say. What I can say is that everybody is invoking the ICJ order. So this, in the Security Council, everybody will refer to the ICJ order. Every UN special rapporteur, government officials, all of them are referring to the ICJ order. So it has some impact. Does it fundamentally affect the state's behavior, the respondent state's behavior? Probably not.
But also, I think what's very interesting in the Israel case is that you have, and we've just had hearings, so we've had a decision yet, Marco, but we have the Nicaragua and Germany case, which is a sort of side attempt to hold Germany responsible for supply of arms to Israel. And so rather than seeking relief directly against Israel, which is obviously in a particular situation or conflict situation, Germany, who's not politically in that conflict situation, Nicaragua is seeking to exert pressure on to stop them supporting Israel. What's your expectation for what the ICJ will decide in relation to that case? And do you think that's going to become a more well-trodden path in future in terms of trying to exert indirect pressure?
Again, a fantastic question. So let's just backtrack just a teeny tiny bit. Remember how the South Africa-Israel case is only about genocide?
Yes.
Yeah. South Africa would have a much easier factual case if it could sue Israel for war crimes.
Yes.
For indiscriminately attacking civilians. That is much easier to prove. But South Africa on the merits will have to prove that Israel or Israeli officials acted with a specific intent to destroy Palestinians. And that is a really, really difficult hurdle. I mean, so far, after World War II, there was, just a handful of cases where this proof was made out. So in the Bosnian conflict, for example, and all of the former Yugoslavia, the court found that only one incident in all of these wars, this July 1995 Srebrenica massacre, where within a few days, Bosnian Serb military people killed 8,000 Bosnian Muslim men and boys. Only that was genocide. Everything else was war crimes, crimes against humanity. Yeah. Rwanda is the only other case where genocide was, properly fully adjudicated, where again, 800,000 people get killed in a few months. It is in Cambodia, on the other side of the world, we all say the Cambodian genocide, killing fields in Cambodia. The Special Tribunal for Cambodia said, no, there's no genocide when one set of Cambodians kill another set of Cambodians. Yeah, so Khmer, political groups, are not protected by the Genocide Convention, but when they killed the Vietnamese and the Cham Muslims, well, that's genocide, even though it's just a fraction of the total number of people killed. I hope that makes sense. Now, yeah. The issue, Angeline, you're really raising is complicity of other states by supplying weapons to a third party that is committing not necessarily genocide, but it could be war crimes, crimes against humanity, any other thing. And this is not a new issue. So it is an issue that has been litigated, for example, in the UK with regard to trading arms to Saudi Arabia, knowing that Saudi Arabia would use them in Yemen to kill civilians in Yemen. Yeah. Now, however, in a lot of countries, you have domestically litigation trying to stop those states from exporting weapons to Israel. Some of these cases are based on genocide, and they rely, they will mention the ICJ Provisional Measures Order. Others are based on other legal instruments, like, for example, Common Article 1 of the Geneva Conventions or the Arms Trade Treaty. The Nicaragua case that was brought against Germany in the ICJ is one such case internationally. So it's about this kind of complicity problem. And thankfully, well, from Nicaragua's perspective, it's not limited only to genocide. The problem, as far as I understand it, is that factually, Nicaragua's case is rather weak, meaning that it's not like Germany is exporting all that much stuff to Israel. And I very much doubt that that case will succeed. Either, certainly not on the merits, probably not also on provisional measures either. If you could bring that case against the United States, the issue would be of a substantially different magnitude.
Yeah, and why did they bring it against Germany and not another state? Because other states are supplying or giving assistance to Israel.
So part of that is some kind of internal political calculation in the government of Nicaragua, to which I'm not privy. The other big issue is jurisdictional questions. So in the Nicaragua versus Germany case, there is a broader jurisdictional basis because both states have filed these optional clause declarations through which they accept the jurisdiction of the court. And so Nicaragua would need to find other arms exporting states that have made similar declarations. And for example, the United States has not. So Nicaragua, even if they wanted to, they couldn't sue the United States. You see what I mean?
Yeah.
Because there's no jurisdictional basis.
Understood.
Sorry, just to clarify that, are you saying the USA is not subject to the Convention on the Prevention of Genocide, or
there's two different issues? So one jurisdictional basis is a compromissory clause under the Genocide Convention, so in Article 9 of the Genocide Convention, and the United States actually is not subject to that. They are parties to the Genocide Convention, but when they ratified, they made a reservation to Article 9, saying they don't accept the court's jurisdiction. By the way, the United States is not the only state that does things like these. So if you want to see a hypocritical example of such a state in Africa, it's Rwanda. So Rwanda made such a reservation. So you cannot sue Rwanda under the Genocide Convention. Congo tried, for example, but the court said no. Yeah.
What about China? Is China subject to Article 9?
Ooh, I would have to check, but I think they're not. I think they also made a reservation, but don't take my word for it. I would have to check. I don't know off the top of my head. Now, the other basis of the court jurisdiction would be these optional declarations. A state simply declares, I accept the jurisdiction of the court for such and such categories of cases. So it doesn't have to be based on a treaty. And here, both Nicaragua and Germany have those types of declarations, and that's what forms a jurisdictional basis.
Interesting. Because I was also thinking what Angeline was, because why would you pick Germany when the USA is the largest supplier? I think Germany's number 2 and Italy is 3. But I think, these legal nuances are really important to understand. Actually, I really wanted to ask you a question that I think we should have covered much earlier. But I think we jumped into sort of evidence and merit, and I wanted you to explain to our audience the composition of the bench, because I think when the two provisional measures orders came out, we sort of saw, it would say voting X number to Y number, and it would have a list of people for and against a specific measure. So I just wanted to understand how are the parties involved in the composition of the bench, and how is that bench considered impartial?
Right. So there are 15 permanent judges of the court, and they are elected by the UN General Assembly and the Security Council. So each judge needs to get a majority in both of these principal organs of the United Nations. And the elections are run under a regional distribution. So there are all these regional groupings in the UN, and there's a set predetermined quota, basically, of, how many judges does each region get. So the judges are meant essentially to represent the major legal systems of the world, and that's what they do. They are elected and they're independent from their states. Obviously, there are better judges and poorer judges, like in any kind of court. There's judges who are really, really, really good at their job, and there's judges that are not so much. There are judges that are really independent and they don't care at all about what states think, and there are some judges that maybe are not 100% independent. And that's just how it is. Now, when you have a contentious case between two states before the court, if either party does not have a judge of their nationality on the court, they can appoint a so-called judge ad hoc. So this is a person, who meets the criteria in principle to be a judge of the ICJ, and they will essentially get appointed just for that particular case. And in, for example, South Africa versus Israel, both South Africa and Israel appointed judges ad hoc. I mean, judges ad hoc, like other judges, are supposed to be independent. A lot of the time, most of the time, they will vote in favor of the state which appointed them, but not necessarily. So, for example, in Ukraine versus Russia, that other genocide case I mentioned, it was the ad hoc judge appointed by Ukraine who ultimately in the jurisdiction judgment voted against Ukraine's most creative argument. So, having a judge ad hoc doesn't necessarily mean, that person is completely in your pocket. They're not. And remember, there's 15 other judges.
And I think to that point, am I correct that the second provisional measures order in South Africa versus Israel, wasn't there at least one part of that order that was unanimous?
Correct. So there was a part of the order on which even the Israeli judge ad hoc Barak, voted in favor, which was about humanitarian assistance.
Yeah. So probably if it's all about, some of this is about how you frame the prayers you're asking the court to give.
Yes.
Presumably, if you frame it in a certain way, it'd be quite hard to say that you're coming out against humanitarian assistance.
Correct. And I mean, the judges obviously will think about how this plays out in whatever their local constituents. I don't know, if you're a judge ad hoc from a country, you're going to have to go live there. So it's you are constrained in a certain way in which other judges are not, and that's normal. But that's why there's at least 15 other judges on the bench. So the judges ad hoc normally cancel each other out. They're never or almost never the tipping point of a case.
We started off, I think, the session thinking about what the role African states were playing in these incredibly high profile and important cases. And I think it is really interesting to see that African states are playing such an important role, but it seems to me that there's nothing particularly specific to identify why it is African states as opposed to, and of course, Marco, you've talked about various other different examples of states who are holding others to account, but there's nothing, I think, specific to Africa about this. Is there really at all?
I think that's right. I think all states are the same in some fundamental ways, and that's that they care primarily about their own interests and their own reputation, and they will do things that advance those.
Yeah.
I just wanted to ask, and this is not necessarily helping us with the conclusion, but Professor Marco, I think Germany is involved in the Gambia Myanmar case, and it's involved
as an intervener.
Exactly, and it's also involved as an intervener in the South Africa-Israel case. Could you maybe tell us what Germany's position in both cases and how the fact that one case is going ahead of the other might be relevant?
Oh, this is a really good example of politics at play. So in the Gambia-Myanmar case, Germany and several other Western states intervened to support Gambia, but really to support the Rohingya. And to say, to the court, look, we know the burden of proof for genocide is a really difficult one, but you shouldn't make this case impossible. be flexible in how you evaluate evidence, and maybe you will find genocide, is sort of the message that Germany was sending. Now in South Africa versus Israel, it's completely in reverse. So Germany, as you know, because of the historical circumstances, sees Israel as sort of, as the German politicians put it, their reason of state. That protecting Israel is sort of the fundamental policy of the German political community. And so they're intervening on behalf to support Israel. And they're going to argue, well, this is not genocide. Maybe there's bad war crimes. Maybe there's violations of IHL, international humanitarian law, but there's no genocide. And so it's the same state really kind of going in two different directions. And the reason why it's doing that is mainly political. And, to an extent, that's fine. It's up to the judges to make their decision on what they think is the best assessment of the law and the facts.
But is it correct to say that because Gambia and Myanmar will be heard, the merit hearing will go ahead before this other one? Will the ICJ then be bound by that? Is it bound by precedent?
So they're not bound by precedent. There's no formal doctrine of precedent. In reality, though, they really, really follow closely what they've said before. It is really, really rare for the court basically to backtrack on something it had said before. So the Gambia-Myanmar case will be a really good test, if you will, of how South Africa versus Israel will go. Essentially, if in Gambia-Myanmar, the court adopts a very strict approach to proving genocide of the kind it had adopted previously in the Bosnian and Croatian cases, then that will mean that the South African case on the merits is much less likely to succeed. If, on the other hand, you can see more approach, a more flexible approach, amenable to drawing inferences of genocidal intent in a more, easy way, then that can bolster South Africa's chances before the court.
And is it the same bench, or is it a different bench?
So that's a bit difficult to say, because the composition of the court changes every 3 years, right? So every 3 years you have a round of elections. Now, so 5 judges will stand for election or re-election every 3 years. When you have the elections, the composition doesn't have to change much, because many of the judges get re-elected, if you see what I mean, and their terms are for 9 years. So it could very well be that the composition of the bench will be identical or nearly identical in the 2 cases, but the bench that is today is a very different one from the one that decided the Bosnian case in 2007. It is 17 years, so there's a couple of judges who are still on the court, but this bench today is a very different one from the one 17 years ago, clearly.
Thank you, Professor Marco, and thank you so much, Angeline. I think this discussion we've had today, it's sort of explained a lot of things that even for me as a lawyer, I've struggled to understand. I guess my last comment or question for you, Professor Marco, for our audience is, in some ways, because you've explained the distinction between genocide and other crimes, like crimes under international human rights law or crimes against humanity, does it mean that genocide is at the apex of these crimes, or are these lesser crimes in some way? Do we have any jurisprudence around a hierarchy of crimes?
That's a really profound question, actually, and one that I've given much thought to. Some scholars and even some courts have referred to genocide as somehow sitting at the apex of a hierarchy, as being the crime of crimes. My personal feeling, however, is that this is a very wrong way of thinking about genocide and its relationship to other international crimes, for various reasons. One, because remember, the definition of genocide is a purely a creature of political compromise in 1948. And we should not, give that creation of that political moment that kind of importance. That's my first point. My second point is that this kind of fetishization of genocide as the apex crime leads to the devaluing of all other crimes. Leads to a really horrible dynamic where different peoples, different communities engage in competitive victimhood, where the word genocide suddenly becomes the only word that can capture their suffering. Yeah, and war crimes and crimes against humanity become peanuts. They become meaningless. And I think that's a really dangerous state of affairs. Whether what's happening in Gaza is genocide or not, to my mind, is much less important than the fact that 34,000 people have died. See what I mean?
Yeah.
I think that word, focusing on that word, is really, really problematic.
I think what I would say is that's probably our understanding from the outside, as people who don't specialize in this field like you, our understanding when we read a newspaper about what genocide means is clearly very different to what the ICJ is looking at when it hears cases before it. And so I do feel that there's this looseness with which this word is used, and it's very unhelpful to us because we just think, if we're African, we'd be like, why in that case is this genocide, but in this other case it's not? But actually it's because probably we haven't understood the framing. I don't know. So
if it's any comfort, nobody understands this word. So in my, in my neck of the woods, again, in the former Yugoslavia, everybody is constantly in a state of, tension and stress around the word genocide to this day. So it's now been 30 years almost that the war in Bosnia is over. At this moment, you have huge disputes between Bosnian Serbs and Bosnian Muslims about whether there was genocide in Bosnia. There's a proposed General Assembly resolution commemorating the genocide in Srebrenica, which is being strenuously opposed by the Serbian community simply because of that word. That word is being used to mobilize ethnic nationalism and to create, again, this sense of victimhood, of how, we are constantly under threat. And I really think it is horrible. The weaponizing of that kind of language is something that is really unhelpful. To me, war crimes, crimes against humanity are just as bad as genocide. There's no moral difference between them.
Right. I don't know. It's hard to comment other than to say genocide is horrible and the misuse of the term is also horrible. But, we will be watching this space and hopefully inviting you back, Professor Marco, as these cases develop, and probably Gambia first, to see, what the arguments are and how flexible the arguments are. Thank you so much.
It was my pleasure.
Thank you so much, Angeline, and looking forward to speaking again on these important issues. Goodbye from the ALN Academy.
Thank you.